What's a will? A last will and testament. They're called different things. There's no magic in the name. The usual name is last will and testament, but do we really know which will is your last will until you actually make the last will and die? The point is, a will is a document that says who gets your stuff when you're gone. A will is not effective until you die. So it does not replace a power of attorney. It's not a substitute for a power of attorney. But a will can be used for a number of important things. It can be used to state how you want your family taken care of after you die. We can put trusts in your will that will take care of people who can't take care of themselves, like children with disabilities or a spouse who might have a disability. We can include tax planning provisions in your will. We can include spendthrift provisions if you've got a child or a loved one who just hasn't learned how to manage money or who has creditor problems. So when you're thinking about how you want things done, a will is one of the documents that we would use in planning your estate. Now, because a will is not effective until you die, there are going to be some limitations associated with it. You're not going to be able to avoid probate, for example, because a will is only effective by taking it through the probate process. You're going to have the will triggering certain legal costs. If an attorney needs to help probate the will, then you're going to have those costs. The other thing that you need to keep in mind is a will only passes those assets which are part of your probate estate, so we need to look at how all of your assets are owned in addition to setting out what you want done in your will. We need to make sure that your assets will flow through the will or that they flow to the people you want them to. Let me use insurance as an example. Most insurance policies designate a beneficiary, and for that reason the insurance company will just send a check to the beneficiary. They don't look to see what's in your will because the insurance proceeds are not part of your probate estate. The same applies to some other assets like annuities, money market accounts which have a beneficiary designation. If you have a joint bank account, it probably goes to the co-owner, or it might go to a pay-on-death designee. You might have land that passes outside of your estate if you have it titled with rights of survivorship. So your will may not be enough by itself. We need to look at other things too. Right now, in 2012, we don't have a lot of estate planning issues, or estate tax issues, I should say, because the estate tax threshold is $5 million per person, but that's going to change if Congress doesn't do something before the end of 2013. So if you plan to live beyond 2013, we probably need to examine whether you have too much money and whether you might be subject to estate taxes. If you do, then we might need to put you in touch with a tax lawyer. So there are a lot of different things that we're looking at when we're trying to structure your estate, when we're trying to plan your will. If you've got questions about how your will should be structured, you should talk to an elder law attorney. We can help guide you through these issues.